To me, that would indicate that he was not keeping up with his bondsman, and otherwise he would have. If you bond out, you got a bondsman. You check in once a week. You would know you have a court date. If you miss a court date, you would know there's warrant. So there's that issue as well. Mr. Coleman, what's the state's position? Mr. Hawkins is charged with unlawful possession of a firearm by a felon. Looks like the bond is currently set at $100,000. There was a court date, March 31st, that Mr. Hawkins did not appear, and so there was a bond forfeiture, and the bond was raised to $100,000 at that time based on that. And then Mr. Macon looks like was hired, filed motions and letter of representation in October. So here is, Mr. Macon, the state's. I don't know why it's printed like this. Oh my gosh. No, I mean, I printed 2 copies and it printed like 1122. It hasn't done that in the past, ever. When I've never seen it do that. It never has done it to me. Okay, so the state filed a reply to Mr. Macon's motion asking for a bond to be reduced. Let me take a look.
Go
ahead.
Summary.
Yeah.
Page 2, it's referring to the defense criminal history, and also on page 2, the very bottom refers to jail write-ups, and that's essentially the state's, what the state would ask the court to take into consideration if you are so inclined to reduce the defendant's bond. Criminal history, including 4 previous felony convictions, 1 for burglary, a felony theft, the possession of cocaine, and a felony marijuana. And he's been also written up by jail staff for possessing contraband in jail and failing to follow and disrespecting the rules of staff.
Yes, Your Honor. First off, Mr. Hawkins, you're unable to make the 100,000.
Hold on just a second. Raise your right hand the best you can. Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth? Thank you. Go ahead. I'm sorry, Mr. Macon.
Would you state your name, please? And you've been unable to make the $100,000 bond, correct?
Yes.
Okay, do you have family and friends that were a reasonable bond be set that you could make?
Yes.
Okay, now you understand you're from Florida, so if you make a bond, you'd have to stay in Jefferson County.
Yes.
And you have friends that you would live with here in this area?
Yes, sir.
Okay. Now, you turned yourself in once you learned there was a warrant for your arrest, didn't you?
I didn't know I had one for my arrest.
But when you learned, you turned yourself in?
Yes.
Okay. Do you understand that you also would be required to wear a GPS monitor and probably a drug patch or anything like that? You comply with all those conditions? And whatever other conditions you were given, you would do. Okay, now, with respect to this contraband, the September 26th, they were Tylenol pills, right?
Yes. I just didn't take them.
You were given them by the jail staff and didn't take them. Then December 3rd, and December 3rd incident was you having your jumper down or something. But you didn't have a knife or anything like that or anything like that. In other words, they wrote you up for refusal to follow written or oral directives. But you didn't jump anyone or beat them up or anything like that.
No, I don't even recall that write-up. I didn't know that.
Okay. I have nothing further on it.
Is there anything else, Mr. Macon?
Your Honor, Damashi, and I'm probably mispronouncing this, Damashi, is that how you pronounce that? Demisha Jones is a witness who's going to say the gun was hers and she put it under the seat.
It's not what she told the officers that day.
And that's what she's going to testify to anyway.
Okay. So for the record, I have reviewed the probable cause affidavit. I also did receive notification, and if anyone has questions for the bondsman's representative is here today, and her company had to hire a bounty hunter to locate and get Mr. Hawkins after that bond forfeiture. So obviously, to me, that would indicate that he was not keeping up with his bondsman, and otherwise he would have, if you bond out, you got a bondsman. You check in once a week, you would know you have a court date. If you miss a court date, you would know there's warrant. So there's that issue as well. Mr. Coleman, what's the state's position?
So the only thing I'd add, Judge, is that he's subject to a habitual offender enhancement, making it 25.99, Judge.
Okay. At this time, based on the nature of the offense itself, the unlawful possession of a firearm by felon, the probable cause affidavit, and the information that was in that, there were 3 vape pens found as well. I know obviously none of this is proven, but it is important to know everybody had different opinions, or the 2 of them, about where the gun was, whose it was. They both said it wasn't theirs. And the fact that he missed court and had a bondsman, and that bondsman had to get a bounty hunter to get him back here, and the fact that he's from Florida, was apparently working supposedly in Louisiana and driving through here to sightsee in Houston when he was arrested, gives me concern about all of that. And so at this time, I'm going to deny the motion to reduce the bond. The bond will remain at $100,000. I'll reset the case for an announcement, and we'll get it moving in whatever direction it needs to at that time. All right.
I was just trying to say, I wasn't never arrested whenever she pulled me over. I wasn't arrested at all.
Oh, yeah. It's right. It's
Mr. Nichols on Marquis Jones. Good morning. Are you Marquis Jones?
It's not.
And Mr. Parker, will your client waive the formal reading of the motion?
you will, Your Honor.
Mr. Jones, in cause number 21-37263, I have a motion to revoke your unadjudicated probation. It shows that you were placed on probation February 23rd of 2022 for the offense of theft of material, and that was a state jail felony, and it was a 5-year deferred probation. Is that correct? The motion alleges that you violated your probation. Count 1 alleges that you committed the offense of evading arrest on June 20th, 2024 in Harris County, Texas. And is that true or not true? And then count 2 alleges that you were at a location other than your residence at approximately 1:30 a.m. June 20th of 2024. And is that true or not true? Did you enter your pleas of true to counts 1 and 2 freely and voluntarily? And did you plead true to those counts because they're actually true? Speak up, please. I have here on the tablet some documents that have your signature on them. And I think I said your plea of guilty instead of true, but your pleas of true. Anyway, all right, so I'm going to find that you entered your pleas of true to counts 1 and 2 freely and voluntarily. Find those counts true. Find sufficient evidence to find you guilty. And at this time, find you guilty of theft of material, aluminum, I guess it goes on, aluminum, bronze,
Aluminum,
copper.
bronze, copper. They were cutting catalytic converters.
And so find you guilty and sentence you in accordance with your agreement to a term of 15 months in the state jail prison. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I've handed you the trial court certification that shows this was an agreement that I followed, and so you've waived your right to appeal. I also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read that written admonishment I provided you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Parker. All right, good luck to you, sir, and thank you for being here. Sure, so here's what I'm going to do. I'm going to grant the motion to set a bond.
Scram device, Your Honor, or?
Hold on. I don't want Mr. Cummings driving at all. All right, so that's going to be a condition of this bond. You're not allowed to drive a vehicle ever while you're on this bond. No one's vehicle, not yours, not anyone else. For any reason, you're not allowed to drive. Do you understand? I'm going to set the bond in your case at $25,000. Again, condition of that bond is no driving. Also, a condition of that bond is going to be that you are required to wear a GPS monitoring device at all times and remain. Do you live in Orange or do you live in Beaumont? Or Port Arthur? Where do you live?
I was in housing out there in Orange.
When you go home, if you make a bond, where's home? Where are you going to be? In
Maybe,
Orange?
Maybe. I'm trying to figure out, I don't know where I'm going to go.
Okay.
I can get back with you on that.
So what I'm going to do is require a GPS monitoring device and that you remain in either Orange or Jefferson County. You need to let your bondsman know they're going to require an address so that I know where that GPS is you're supposed to be. And obviously you're still on probation. The same curfew applies. You're not to be out of your house past 10 o'clock at night. And also going to require I think it's probably because I'm requiring the GPS, a little more cost effective to do the handheld breathalyzer. So you're going to be required to have the handheld breathalyzer. You are not to drink alcohol ever. If you test positive, if you miss blowing throughout the day. Okay, you can go back with the bailiff. Mr. Matuska, you have Michael Victoria. Good morning, sir. Are you Michael Victoria?
Good morning.
And this is cause numbers 21-36410 and 21-36411. Mr. Victoria is charged with murder in each of these cases. Mr. Matuska, what is the announcement?
Your Honor, at the last setting, I informed the court that had about 48 DVDs in this case.
Right.
This morning I checked, I'm on 23. I'm about halfway there. And that also includes hundreds of documents I've gone through. So I'm getting close, but I would ask for one more regular recess.
Mr. Smith?
Judge, I completely understand this is almost a bucket just with the two cases. So.
Right. All right, so I'll do a normal reset to give Mr. Matuska some time to complete all of that discovery, come out and visit with you about it. We'll see if we can get an announcement at the next court date possibly. Okay, you can go back with the bailiff.